My lord, in item number 20, personal appearance has been given. It is a matrimonial dispute. So whether it can be taken up in,
We'll have it
Chamber.
in camera.
yes. That is, my lord, in this
Mr.
case,
Gupta, you're in this case.
I'm for the appellant.
Okay, we'll have it in camera.
yes,
Okay.
Lord,
Both the parties are here.
yes, Lord,
Okay. Get it, Babu.
That's 12:45. Yeah.
How long should it take?
it will not take not much more time.
We'll do one thing around 12. We'll rise it around 12:40.
12:40.
12:40. You
My
come
lord,
to the
what-
chamber at 12:40.
I have filed, my lord. I may be allowed to call for that.
No, this is for IF or what?
Under section 24 of the.
Bring it. Otherwise, also we'll in camera we can talk and 12:40. 12:40. पता आगे आगे उठी तो नहीं. Okay.
20.
May I please, your lordship? Lordship, I beg to mention item number 19, your lordship. We have taken the consent of the other side.
Yes.
Matter may be taken up after vacation, your lordship. I'm on behalf of MS S. Roy.
Item?
19.
Just a minute. Allow my mobile handset की बात हुई थी. 22, 20, 22.
তাৰমানে হেৰি হ'ব নেকি কিবা আনিছে নেকি এইটো জমা দিছে নেকি
এইটো কি বস্তু? Mobile handset.
মোবাইল হেণ্ডছেট বুলি কিয় আছে নেকি
What is this mobile handset?
What exhibit done before the trial court, my lord?
আনিছে নে অ' য়েছ এইটো এটা ডাব্বা আছে বক্স এটা হা
What is the requirement?
It is actually it is not requirement because only on the ground of cruelty this suit has been passed.
Okay, we'll try to do something. Yes, madam. Yes.
Not much more requirement. my
Okay,
lord.
madam, at 19.
Item number 19, your lordship.
Yes.
Matter may be taken up after vacation, your lordship.
Okay.
I'm on behalf of MS S. Roy.
Okay. Yes, PP, ma'am.
We have informed your lordship.
Yes, on a prayer made on behalf of the appellant. Matter is adjourned to be listed after the puja vacation.
Oblige, your lordship. May I please, your lordship? I beg to mention item number 22, lordship. Kindly adjourn the matter for the day, lordship.
Ready to supply list?
Lordship, immediately after vacation, lordship. My senior is on legs, lordship.
On legs at 10:30.
Not
lordship,
legs,
what happened, my lord?
My senior elder sister died yesterday night.
You're not equipped with the facts. You say he's on legs, then somebody passed away.
Sorry.
Then it was
Sorry,
younger
lordship.
sister, then elder sister. Are you
No.
sure what has happened? Yes, Mr.
A younger sister of the SRS
Okay,
Hospital, my lord. Yesterday night, my lord.
Okay, no, that's not the issue. We'll adjourn it.
Immediately after.
This court has been informed that the learned senior counsel leading in this case has suffered a bereavement. Para? A bereavement, and accordingly, adjournment has been sought for. Para? List after the puja vacation. Yes.
Oblige, oblige.
Please, your lordship, item number 13, lordship, the objection had been filed,
Yes.
but if it is not in the
Bring it.
highly applied.
May I please, your lordship? May I please, your lordship? Lordship, I beg to mention item 5, lordship.
Yes.
But kindly adjourn the matter for only today, lordship.
5. It'll go after the vacation.
Yes, lordship. Yes,
Why is it for orders?
yes, lordship.
Why is it for orders?
Lordship, I had taken the step, lordship, to respond to, and whether it was start or not, I am not able to see the
You
record.
be here. It
Yes,
may be
sir.
4 steps.
Yes.
We are not passing any orders. We'll check the records and pass orders.
Yes, lordship.
Okay.
Yes.
We'll not take up the matter, don't worry.
Yes.
But it may be 4 steps.
চাকৰি ইয়াতে নাই মোৰ তাত আছিলে কি হ'ল ক'ব নোৱাৰো উলিয়াই
May I please, your lordship? Lordship, here,
22 matter not yet
yes,
admitted.
lordship, not admitted,
Why?
but tried for mediation, but it failed. So possibly that is the reason why.
We'll admit this.
Lordship.
heard Miss. Call for the record. This will call for the record. This will please. Heard Miss B. Sharma, learned legal aid counsel for the appellant, whereas Sri M. K. Sharma, learned counsel, is present for the respondent. Fine. Full stop. This is an appeal referred under section 28 over. Appeal under what?
Under section 28,
28.
Yes.
Of the Hindu Marriage Act 1955 against an order dated so and so, passed by so and so. Para. This court wide order dated (29/6/2022), while issuing notice, had called for the records. Thereafter, it appears that the matter was sought to be settled through mediation, which had failed. So, para, admit. Records are already here. Asa, no? Admit. The records have already been transmitted to this court pursuant to the earlier orders. List for hearing in its turn.
apply.
Only one respondent, no other.
Yes.
respondent?
No other.
If connected with item number 20. 21, my lord. Lordship, we have filed,
Of the
What?
supply list.
yes,
Yes.
maybe taken
The
a
matter had come up day before yesterday, my lord, regarding that additional affidavit, the issue pertaining to the absence of the public prosecutor, my lord.
Oh, yes, yes.
That matter.
Lordship,
The affidavit has
here
come back.
also we have filed one additional affidavit. We verified the records, we couldn't find it, but lordship system is showing. We have already filed.
You have filed the additional affidavit in which case?
Both the cases. His case, the matter.
In my
it's
case,
on
item
record
21,
today.
it has come on record, my lord.
Today it has come, other day it didn't come.
And the, you, who the appearing in two, item number 2?
Two,
Additional affidavit is not with the records.
could not paste it there, my lord. Paisa, no, something? Additional affidavit or copy paisa, no?
I is for what?
I is for suspension of sentence, my lord. In both cases,
Conviction under what?
in my case, minus 6 of the POCSO Act.
Other one,
Oxford.
302.
Oh, these are not connected.
Not connected.
No, the issue is regarding trial was conducted without the PP,
PP.
public prosecutor.
Okay. Oh. Well, the cases are not connected. The issue may be, which
Issue is-
arises for consideration may be the same.
So lordship, may I pray both the matters be taken up
We can
together?
have it for hearing.
Hearing,
My
my
lord,
lord.
can have it for hearing, your lord.
We can have it for hearing. See, that may be one of the grounds, but whether it will vitiate
Enter trial.
the trial, that's one question, but we can go on to the merits of
My
the
lord,
case.
the independently, the merits of the case may also be examined.
Because had it been that your representative was debarred, matter would have been different.
Yes.
You have been given chance. Now, what the court has said, we'll have it for hearing, okay?
After the vacation?
Yes, we'll fix a date.
My lord, fix a date.
Matter of which year?
Mine is 2022, my lord. It's been in jail for last 2 years, more than 2 years, my lord.
Boxer matter, step in his turn. Item number 2 and 20, 20 and
21. 21, my lord.
Heard the learned counsel for the parties. Full stop. Paper book has been prepared and have been furnished to the learned counsel. Para, list for hearing in its turn. Okay,
My lord, can I fix a date?
not fixing a date, 23-24 matter.
Both the matter, my.
My lord, my matter is from 22, my lord, since I is pending.
Doesn't matter.
9.
Now we'll have it, there are some old matters also.
Well,
But
actually-
the penance is not much, we'll have it, don't worry.
Obliged.
Deeply available.
No, it appears ordered.
May please, my lord. My lord, today for consideration of the IA for suspension of sentence, madam. Paper book is ready, my lord.
What is the conviction under?
Conviction at 302, my lord. IA, we are pressing, my lord, only on one small aspect, my lord. That the conviction is based on the evidence of PW3, the son of the convict, my lord. Convict, she is a lady, my lord. The allegation of she have murdered her mother-in-law, my lord. And the son of the convict is the eyewitness. No, but that witness, evidence, my lord, it does not corroborate, and it has with the
Inconsistent.
yes,
He is a child witness of all.
child
Child witness.
witness.
The procedures have been followed for,
Yes.
Then
Otherwise, those
we'll consider the main appeal, okay?
today, my lord.
We'll hear the main appeal.
Lordship. Since LCO has been received, let's an.
Paper book is ready, man. Paper book,
Just-
we have been supplied with the paper book.
Though the IA has been filed for suspension of the sentence, comma, the grounds taken would touch upon the merits of the case, full stop. Since the paper book has already been prepared and copies thereof furnished to the learned counsel for the parties, please the appeal for hearing immediately after the,
If I may
without
pray
case.
for a date, my lord.
immediately after the.
Maybe.
This is a special bench, it will come. There are
After,
not much matters. Okay.
Deeply obliged.
Four to হেৰি হৈছে নেকি? ও 5 to mention is. 4 to হৈছে নে? ও 4 to আমি ক'লো ন চাই ল'ম বুলি।
So time may be cut off.
You have received copies of what?
Okay.
Paper book has been prepared.
No, Lordship.
Okay. Okay, let the paper book be prepared.
Lord.
Okay.
Yes, I've received the paper book or what, copy or what?
Paper book বনোৱাই নাই।
No, thank you for.
Lordship, I is pending.
This appeal was admitted
Yes, Lord.
on 10/11/2023. Full stop. The respondent number 2, while Ms. A. Begum, Learned, additionally PP, is present for the respondent number 1 state, comma, the respondent number 2 has entered appearance through your name,
People.
B. Borman, Ms. B. Borman. Full stop. Let the paper book records have come or not? No? It appears that the records have been received pursuant to the order dated 10/11/2023. Para, let the paper book be prepared and thereafter the matter be listed.
Like.
Five to homo listening.
Objection given file proceedings para posted. File.
Five, what was your prayer?
Lordship, step has been taken in this case.
Let us see what has been taken. Received. as per office note dated 19/12/2023, notices were issued to the officer in charge of the concerned PS. Full stop. The subsequent office note dated 8/5/2024 reflects that records have been received. Full stop. However, there is no remark or there is no note with regard to the completion of service upon the respondent number 2. Para, let a note be prepared with regard to the service of notice upon the respondent number 2 and the matter be listed.
Grateful.
But together. I think that I could.
Need to, Lordship.
No.
Lordship, the matter has been admitted, but one of the grounds of my challenge is the appellant is a mentally unsound person. In fact, the witnesses in their cross-examination has admitted that. So if a report can be called from about his mental health,
While admitting the matter, this issue was not raised.
no, my lord. In fact, your lordship comes to page 21 of my memo of appeal, with part of the impugned judgment
Why don't you file an IA
for suspension.
suspension? You take that ground, then we can call for records on the oral period. It will be difficult for us.
My lord.
Maybe at the time of admission, you could have urged this point. Okay. Three, D.K. Bhattacharya, learned counsel for the appellants, submits that the appellant is mentally unsound
Unsound.
and he wishes to file an appropriate IA in this regard. Full stop, para. Let's para, in view of the above, matter is adjourned to enable filing of any IA if so advised.
Lovely.
Item 7 and 8.
Mr. Ali,
My lord, these two appeal, my lord, out of same judgment, my lord. But my learned senior, my lord, is out of station today,
okay, we'll have it some other day.
lordship.
Is it otherwise ripe for hearing?
No, my lord, this for consideration of suspension of sentence,
Okay, you are pressing that.
Lord.
Okay, we'll have it after the vacation.
Lord.
meeting. Though we are Ali, learned counsel for the appellant in criminal appeal 32 of 2024 is present, comma, a prayer for adjournment has been made on behalf of Sri H.R.A. Chaudhary, learned senior counsel, appearing in criminal appeal 469 of 2023 on personal grounds. Full stop, para. In view of the above, matters are adjourned. Matters are adjourned to be listed immediately after the
Lord.
puja vacation.
Okay.
May I please, Lordship? This appeal has been already admitted, Lordship, and LCR has received, Lordship. Paper book may be required, Lordship.
You're a legal aid counsel, madam.
Lordship.
Heard Ms. D. Borpujari, learned legal aid counsel, who has informed this court that by the order dated 6/5/2024, the appeal has been admitted and records called for. Records, I say?
Records are here.
Received,
It
Lordship.
appears, para, it appears that person also heard Miss S. Jahana, who has informed that pursuant to the aforesaid order, the records have been received. Para, let the paper book be prepared and the matter be listed thereafter for orders.
Obliged.
Item 10.
That is your lordship. Lordship, as per our last order dated, we have already taken steps upon respondent number 2. Office note dated 10/9/24, lordship, service has been completed.
Foxonic. Service is not picked up.
Also, let's say.
Could not be served. Could not be served.
Otherwise, in 302 matter, service of notice is not mandatory. Yes.
There is one, his wife has received,
Wife is
reverse side.
Acha.
Noted.
Under the old CRPC, wife is not the proper person.
Informant wife.
There is an office note on 10/9
10-9.
saying that service report, it should be on respondent number 2 has been received back from the CGM Udalguri after its service, which is at flag N. But there is a communication from the CGM Udalguri whereby it has been stated that the notice could not be served.
Oh,
I personally could not be seen.
Hmm?
but my learned friend is saying that wife has.
It's one in and vernacular dot effect, right?
Okay, office note. Office note, right.
48 more copy.
Sita Tati. Sita Tati 20. Vikas Tati. Okay, very cooperative. We'll accept this.
Otherwise, under old CRPC, female will not be the right
Had it
person.
been a POXO or some other thing, matter would have been
Ah,
different.
this-
In view of the office note dated 10/9/2024, read with the intruders there too, comma, service upon the respondent number 2 is held to be complete. Records have come.
Yes, Lordship.
Yes.
Para. It appears that pursuant to the order dated 12/6/2024, when this appeal was admitted and records called for, comma, the records have been transmitted. Uttam. Let the paper book be prepared and the matter be listed thereafter.
Elliot.
May I please, your lordship. The appellants have convicted for life, in the meantime, I have filed IA. And the service is completed. My lord, learned friend, my lord, has not filed the objection.
Acha,
Okay.
this is 11.
I have to put,
I think the informant has expired as per Lawajima court's order.
yes, yes.
Acha,
That was there.
acha.
Conviction under what?
Under section 302, my lord, the main check.
Okay, the paper book is there, we'll hear this matter.
Lordship, yes.
What are
And-
the grounds you are taken in the IA? Any special grounds?
Well, today, my lord, still I am not ready, my lord, because my learned friend has not filed objection. I thought that without objection, better not take.
No, have you taken up any independent grounds for bail or suspension? Or is it on the merits of the case?
No, my lord, on the basis of PW's, my lord, statement.
It's on the merits. If you had made out a case of some exceptional, some illness or some,
No, acceptable ground is not here on merit
if you are
because
going into the merits, we have the paper book, we'll hear this. Okay, you come prepared.
yes, ma'am.
Okay,
No.
the IA has been filed for suspension of sentence, comma, it appears that the paper book has been prepared and has been served to the learned counsel for the parties. Para? List for, it's matter of 2024, you are behind the bar since when?
My lord, since my lord, judgment, my lord, that 31/2024, my lord.
No, that is the judgment.
Yes, from
You're
the
in
judgment-
you're in behind the bars in
from-
custody.
since the pronounced the judgment.
August 22.
List for hearing in its turn. Okay.
Obliged, ma'am.
Foxo. Rajan,
Maybe so after some days, my senior is only there on court number 14.
Who is your senior?
F Hawk.
Yes, madam, what do you say?
Lordship, in the
Anything?
POXO matters, of course, I couldn't see whether the service is complete. Actually, files were being arranged. so- Oh, honey. Okay.
You are for?
I
Informant.
want
The father of the,
Informant.
father of the victim.
Then in that case, in the meantime, we'll file our objection if your lordship allows.
Yes, yes, there is an IA.
There's
IA
an
for
IA.
suspension.
Yes, but suspect.
Uh, This appeal was admitted on 8/4/2024. Full stop. While Miss S. Jahan, learned additional PP is present for the state respondent number 1. Miss S. Sharma, learned counsel, has entered appearance for the respondent number 2 informant. Both the learned counsel pray for and are granted 3 weeks time to file objection to the IA.
Apply.
Apply. Yes.
May I please, Your Lordship? Well, this is an appeal where appeal has been admitted and it was pending for the suspension of the sentence, my lord. Well, before going into that, my lord, you kindly take up my IA in this matter.
Hmm.
Well, this case, my lord, very peculiar in nature. Well, there's 2 appellant,
Conviction under?
well, the 302 now. Well, prior to that, what happened, that's very important. That you kindly take up my IA. These 2 convicted person, my lord, father and son. The father is now 80 years in old, my lord, and he is virtually in the deathbed, my lord, bedridden. And as far as my information, he is also in coma. Day before yesterday, that is the instruction from my client. But whatever it may be, my lord, the situation here is that these 2 appellant initially after the trial were acquitted by the court, my lord, Learned Sessions Judge. Both were acquitted. Thereafter, the informant filed an appeal against acquittal, my lord.
Yes.
Then, after the hearing the appeal, my lord, the High Court came to a finding that is very important in this case, my lord. Lordship kindly see, while remanding back, my lord, page 66, 166, my lord. It starts from 166, my lord. The judgment by our High Court division bench. It starts from 166, my lord. Thank you, Lordship.
Yes.
Then the relevant portion, my lord. The straightway I'll go to the relevant portion, paragraph 12, my lord.
Paragraph
12,
12.
12. 1, 2.
This was criminal appeal 17.
In this, my lord, the IA, my lord. Yes, criminal appeal 17.
That was by the informant.
That was by the informant, my lord.
Yes. Then what happened in paragraph 4?
Paragraph 12,
12, okay.
page 170.
Yes, we have got.
May I read, my lord?
Yes.
A stand has been taken by Mr. M.S. Tate, learned counsel for the respondent, accused person, that the evidence of PW1, Mr. Basiruddin in cross provided that the accused Abdul Aziz has told him that the deceased Almas has entered his house upon being injured by someone outside, and after entering he has died. But again, the statement of PW1 in cross is not the evidence of PW1, but it is merely as to what was told to him by the accused Abdul Aziz. Accordingly, in absence of any such explanation by the accused Jasmat and Mukhtar, the Jasmat and Mukhtar is not the accused, my lord, not indeed. Explanation in absence of any such explanation by the accused Jaspat and Mukta, they are not in the trial, my lord, and Ziaur, as regard to the last in together theory, and in absence of any explanation by the accused Abdul Aziz under 106 of the Evidence Act, we are of the view, this is very important, we are of the
What are your
view,
names? What are your names?
Aziz, Abdul Aziz and Jasmat Ali.
Abdul Aziz and Jasmat.
So, my lord, we are of the view that the instant case, the evidence on record is sort of being adequate to arrive at any view, but you can mark it any view, as to what had happened, let alone forming two views out of which one is in favor of the accused and one in favor of the prosecution. So it was very clear, my lord, whatever the evidence has been produced by the prosecution, the court could not find any material to form any kind of view, neither in favor of the accused nor in favor of the prosecution. In view of the inadequacy of the evidence, we are of the view that the matter requires to be remanded back for taking further evidence so as to make out the circumstances which resulted the death of the deceased complete. So that is the direction, specific direction for the further evidence. Virtually in the paragraph 13, it was remanded back for retrial because the court was also directed to take 313 also. Accordingly, we remand the matter back to the learned trial court for taking further evidence, and in doing so, the learned court shall give adequate opportunity to the accused Jasmat, Mukhtar, Ziaur to render their evidence for discharging their burden. So we have also given the opportunity for the defense evidence for discharging their burden under the last in together theory, and also to the accused Abdul Aziz to explain as to how the dead body of the deceased was found in the house. In doing so, learned court shall also give an opportunity to both the parties to cross-examine any of the witnesses that have already been examined. So, who has already been examined, they can be again re-examined, and also bring further witnesses for their examination in chief, that is for the prosecution, my lord, as well as their cross-examination, and for the purpose the parties may bring witnesses they would like to bring, provided otherwise admissible. Now, upon conclusion of the evidence, further opportunity may be given to the accused person to make their stand under section 313 CRPC, and upon the evidence on record being complete, the learned trial court shall pass the fresh order by giving a consideration to the whole of the evidence, including the evidence already recorded. So that was the direction by the division bench. The first about the paragraph 12, it is very categorical, my lord, that whatever the evidence collected during the earlier trial, the court has failed to take any opinion on, neither in favor of the prosecution nor in favor of the. So that was absolutely, there is no material at that time. Now, when it was remanded back to the trial, now the trial court, the prosecution has categorically stated, my lord, lordship kindly see, page 173, my lord.
173.
Yes. Paragraph 7. That is the judgment, my lord. It starts from 173. This is the fresh judgment, my lord. Paragraph 7, my lord.
Page 176.
176, my lord. On receipt of the case record, this court gave the opportunity to the sides to adjudicating their evidence on the basis of the judgment passed by the Honorable Court, Guwahati High Court, for further evidence as tendered by the other side. The learned PP had declined to produce further evidence and submitted before this court that the burden lies upon the accused to establish their defense against the last in theory and the 106 of the Evidence Act as directed by the Honorable High Court. There is no such direction, my lord. Where is that direction, my lord?
Only for the dead body part, 106 you mean?
Yes, but there is no direction from the High Court that your burden lies and you have to explain, you have to adduce evidence. That's not. It was the direction first, it is for the, because High Court has failed to, whatever may be the evidence earlier, High Court couldn't come to a conclusion, man. So High Court has decided to remand it back and take the fresh evidence. Fresh cross-examination, fresh defense, fresh 313, everything.
Yes.
Now, without doing so, my lord, see, now I have been convicted on the basis of earlier evidence, my lord. So learned trial court has, I don't know how, my lord, he has appreciated the evidence which High Court has failed to find. Very strange, man. But the division bench has failed and opined that we couldn't opine anything, and we are any view, we can't take any view. And the trial court on that same evidence has now convicted us. And earlier we are acquitted on the same basis of the evidence. It was just the reappreciation. Which is otherwise also barred.
Let us see the liberty again given at the time of remand.
That is the, my lord, the page 170, my lord.
13,
Page 170.
7113.
It starts from 170 is the page
And
one.
let us see the direction for remand at 17113.
Yes, 12 from, it starts from 12.
12 we have read.
Yes.
That is the discussion then
Yes,
13.
13 again, my lord.
Yes.
Accordingly, we remand the matter back to the trial court for taking further evidence. And in doing so, the learned court shall give the adequate opportunity to the accused. So it was further evidence they will produce, my lord, and will give the adequate opportunity to us to their render evidence. So discharging their burden under the last in together theory, and also to accuse so to explain how the dead body of the accused was found in house. In doing so, learned court shall, this is important, give an opportunity appropriate to both the parties to cross-examine any of the witnesses that have been already examined, and also to bring further witnesses for their examination in chief, as well as the cross-examination of the purpose of the parties may bring to end. And upon conclusion of the evidence, further opportunity may be given to the accused person
Yes, yes.
to make their 313. Man. So why 313? That means the prosecution has to lead evidence first, then only 313 comes, then my evidence comes back. It's not the otherwise, but that's the procedure to be followed. There's nothing that short of been followed. And simply on the basis of the earlier material, this time I have been convicted just because the matter was remanded by. That's what I can understand it.
Yes, madam, what do you say?
At the outset,
See,
I'd like-
otherwise the matter can be heard, but he is trying to make out a case. The father is 80 years old and is bedridden.
and the son is also, he is also not well. But
Son,
at
he
the
has not said
outset, my
anything.
learned friend had filed the objection, but objection perhaps is not on record.
It has come.
It has come. That's it. There was a requisition made in the morning,
Yes.
and if it has come, it's all right.
Objection has come.
A lot. Now of course, Lordship has seen, this is a very strange case, unusual case. Now, initially I'll just add up few lines. Initially, the trial court had acquitted on the grounds. One is that last in theory is not established. Because there was a DW who said that the victim was with him.
No, madam, before we go to the discussion of the trial court,
Lordship.
there cannot be a rediscussion in a criminal case.
Hmm.
There is no concept of a review. The remand was made on a specific issue that since it does not, we cannot take a stand either this side or that side. We give a chance because initially there was an order of acquittal.
Yes,
The informant was aggrieved, came before this court.
yes,
She tried to make out a case that there were evidence which were probably not put in a proper manner.
yes.
So court on being satisfied said that may remand,
Huh.
we give you liberty, adduce evidence, try to make out a case.
Huh.
They declined to make adduce fresh
The
evidence.
trial court order is take fresh evidence along with the including evidence.
No, and
Whatever evidence is
along
there.
with the including evidence, that is not there. Why-
Perhaps it's there, Lordship will see the
Perhaps the new evidence also, madam, if necessary.
new evidence along with the prevailing.
Yes, but come to the paragraph this one, 13.
13.
Lordship will see
171.
paragraph 14, one line I'll show.
Yes, yes.
Paragraph 14, middle part. The learned trial court shall pass a fresh order by giving a consideration to the whole of the evidence,
Yes.
including the evidence already on record.
Yes.
So they have to take everything and pass order. Now, why I said about the trial court's order is that because trial court said last seen theory is not established, High Court said last seen theory is established.
No.
No.
No, like High Court said, Lordship will see.
Where?
No, it's
No, no, no.
Lordship
That
said,
may be an obiter. In paragraph 12, where is that?
no, Lordship will see that last seen theory, paragraph 12, Lordship will
Yes.
see.
Yes.
As far as bail is concerned, of course, has to be prima facie. These are actually matters of hearing. Lordship will see paragraph 12, a stand has been taken by so and so. Lordship will skip that part.
Yes, yes.
But again, the statement of PW1 crosses that PW1, but is merely was told by him 106. No, Lordship will see. I'll show.
Where it is established?
Lordship will see paragraph 10. Last seen theory
Okay.
of accused Jasmat so and so would therefore start at the time 10 o'clock. Because what trial court said, DW has met the victim at 9 o'clock. And the grandmother in her evidence said that the
No,
victim was taken.
Those are the evidence, but
Huh,
this court in the earlier round
yes.
has come to a categorical finding
Yes.
at page 12.
Page
That we
paragraph
are of
last.
the view,
Yes.
consistent case, the fourth line from the bottom,
Yes, my lord.
view that
The instant case, the evidence on record
is short of being
is short
adequate
of being
to arrive at
adequate.
any view.
Yes, insufficient. They did not adduce.
So
Neither explanation under 106 was
the
taken, nothing was
consideration
done.
has to be either on the, mainly on the new evidence which,
Huh.
because the acquittal was the subject matter of challenge.
Hmm.
So what do? You adduce fresh evidence
Fresh.
and give them opportunity even
That should be
to
done.
the extent of 313.
Huh. Following the High Court's order.
But nothing has been done.
Nothing has, this is admitted fact, nothing has been done. But as far as merit of the case is concerned, during hearing, we can place something. Because new chain of circumstance was taken by the subsequent court.
Madam, if you holistically also look into the matter, the appellate court had all the powers either to
Yes.
confirm the judgment
yes.
or set aside the judgment. The remand was made.
Hmm.
Remand, though there is an observation that earlier evidence will be taken into consideration,
Huh.
but there cannot be a reappreciation of evidence
Mhm.
by the same court.
Yes.
It is not, it is barred by law. On new evidence, yes, that is why to the extent of
Yes.
313, the statement,
Yes.
there is a cursory distinct statement that even the obviously new evidence has to be linked with the old evidence. But on the basis of the existing evidence, where there is an acquittal,
Yeah.
he
And
takes
then
another view
subsequent.
by the same court.
This is bizarre. In fact, this is very unusual, very bizarre. But he had taken some few new chain of circumstance. That is a matter of trial. As far as bail is concerned, I'll not object.
And
Lordship.
after in today's context, when the
Huh.
appeal, it was not a revision, to appeal is allowed by the informant. Appeal could have been filed application. If
That-
the prosecution was not interested to adduce evidence,
Huh.
at least
This
take
is what
advantage
is
of
said.
the judgment.
But,
Peakley said that I am not going to adduce any evidence.
but explanation, of course, there was a High Court's order to get explanation from the two accused on how the body
Explanation
was
will
found.
come only when new evidence will come.
New evidence will come.
They were armed with an acquittal order. Why should they again go for explaining?
Yes.
Absolutely, man.
As far as bail is concerned, that has to be on prima facie ground. So I'll not, I'll leave it to your lordship.
What is the issue of the son?
He is also, my lord. Father, both are inside and the
No,
the
son,
son
what
is
is the
also,
problem?
my lord. He is also, my lord. There is a surgery on him and the,
What kind of surgery?
no, he was, he's, I have it, my lord, just.
When? What surgery?
It is on 16th August 2024, my lord.
What is the surgery?
Emergency for,
Is it a part of your this thing?
no,
IA?
no. It is subsequent because we later on we got it, my lord. After
IA, what are your grounds for suspension?
no, suspension is the prima
No,
facie.
that is okay. And other medical grounds?
Medical grounds is the father is the medical ground. I have annexed it. Apart from 80 years, my lord.
Some scrotal swelling is there as far as Jasmat is concerned.
And he was.
Then I'm not able to get it.
We'll consider for the father, Mr. Bora.
Well, the son, because this judgment is not going to stand, my lord.
We'll have a early date of hearing.
Because this judgment is not, because he got the acquittal, my lord. On the same set of evidence, he is
Under-
now
under- we'll
convicted, my lord.
Hear it, we'll fix a date. Hearings, hotels will. Okay. Heard three. Heard 3 AM Bora, Learned Senior Counsel assisted by VH Chaudhary.
VHR.
For the applicants who by means of this application filed under earlier Act 389 of the CRPC has paid for suspension, so and so. Also heard Miss S. Jahan, learned additional PP. Full stop para. It is the case of the, please have your seat. Please have your seat. It is the case of the applicants who are two in numbers that in the trial, there was initially an order dated 28/9/2015 passed by the additional session judge FTC Borpeta, whereby they were acquitted. Full stop. The sage judgment was, however, the subject matter of an appeal, being Criminal Appeal 17 of 2016. Full stop. This court had disposed of the said appeal via an order dated 24/7/2019, whereby by making the following observations. Paragraph page 171. Paragraph 13 and 14. Full stop. 3. Bora, the learned counsel, by drawing the attention of this court to the impugned judgment and judgment dated 5/6/2024 has referred to paragraph 7, whereby it has been recorded that the learned PP had declined to produce further evidence and further evidence, full stop. It is submitted that on the basis of the same evidence, comma, a contra view could not have been taken by the court, and it appears, and it is submitted that only because the matter was remanded, comma, the conviction has been made. Full stop. Para. It is also submitted that the appellant number 1 is aged about 80 years and is seriously ill and bedridden. Full stop. It is so far as the applicant number 2 is concerned, comma, it is submitted that he had undergone
That is surgery in testicles.
surgery recently. Full stop. This is not a surgery paper. This is only a USG. Okay. Full stop. Miss Para. Miss Jahan, the learned APP, has, however, seriously objected to the prayer for suspension of sentence, full stop, by referring to the objection filed on 23/9/2024. It is submitted that in the remand order passed by this court on 24/7/2019, it was observed that the matter could be reconsidered on the basis of the existing evidence also, apart from the new evidence which could be led, full stop. It is submitted that the last sin theory was duly proved, on the basis of which the conviction has been made, full stop. Para. The rival submissions have been duly considered. Para. Do the learned counsel, senior counsel for the applicant has laid stress on the aspect of not leading further evidence in spite of the clear observation of this court in the order dated 24/7/2019, comma, this court is of the opinion that instead of going to that aspect of the matter at this interlocutory stage, comma, the medical condition of the applicant number 1 is taken into consideration, full stop. It is submitted, comma, as submitted, comma, the applicant number 1 is bedridden and is seriously ill, full stop. In view of the above, seriously ill, and this fact has not been rebutted by the learned additional PP, full stop. Para. In view of the above, comma, we are of the considered opinion that interest of justice would be served if the sentence upon the applicant number 1 is suspended for the time being, full stop. Accordingly, let the sentence upon the applicant 1 be suspended till the consideration of this appeal on merit, full stop. The applicant number 1 is accordingly allowed to go on bail on furnishing a surety of rupees 20,000. Oh, no, a bond of 30 with a surety of a like amount, subject to the satisfaction of whom? He's in the jail.
He's in custody.
Satisfaction of
Station check.
Learned session judge, my lord.
which court?
Borpeta, my lord.
FTC?
Borpeta, my lord.
No, it's a session judge. Borpeta.
Borpeta session judge.
Full stop. The applicant, however, on the learned session judge, Borpeta would, however, impose necessary conditions while allowing the applicant number 1 to go on bail. A paper book is prepared.
No,
My lord, earlier paper book.
In the earlier paper book
book-
was there.
Yes.
Since it appears that in Criminal Appeal 17 of 2016, paper book was prepared, and as no new evidence has been led, comma, the same paper book may be tagged with the records of this case.
but the subsequent judgments it have to be again
Judgment
added.
doesn't matter.
The LCR may be called for intimate.
LCR has been called for already, I think.
Okay.
Let us check.
It's called for now.
Criminal appeal, we presume that LCR is called for. Yes, it is called for.
Then man, kindly
Yes, ma'am.
fix an
I see.
No.
The office may give a fresh requisition for the LCR.
after receipt of the LCR, my lord. That may be, my lord.
And the matter be
Hearing.
listed for orders after the receipt of the LCR.
of that.
Okay.
Me too. Criminal code কেনেই কৰিব পাৰিব হাইকোৰ্টে ৰিমাণ্ড কৰিছে হয় only on the new evidence that may be led আগৰ evidence টোতে criminal post scope আছে এইটো review হ'ল দেখোন
This high criminal 243 of 24 is pending for suspension of sentence. Healthcare receipt and they have also filed object. All clear records.
Your suspension is based on the you're
Merit.
going to the merits of the
Merit.
case
Merit.
merits
Merit.
merits what is the conviction under which you
3034 I and 323 for
on merits it will be difficult
if you kindly seek the matter for hearing. They
we'll have the paper book prepared as the records come
Yes.
records have come
record.
we are not dismissing it will remain but will pass okay though the IA has been filed for suspension of the sentence comma it appears that pursuant to the order dated 13/3/2024 comma the records have been received full stop let the paper book be prepared and the matter be listed for orders thereafter to fix a date of hearing.
Of like.
Now, my lord,
Lordship, before he starts here, Lordship, you preferred an IA. Lordship, we have not filed our objection yet.
You'd like to file objection?
my-
My lord.
IA for?
my lord, the IA is basically for suspension of sentence on health ground. My lord will kindly appreciate one fact, my lord. Here is a case, my lord, where three men were convicted, my lord. Now, my lord, allegedly the person who has dealt the fatal blow, I mean the stab, because the deceased died because of a stab wound. The person who allegedly stabbed is on bail for 2 years, last 2 years. And the allegation against my client and the other person is that they hold the hand. I'll make submissions of merit, my lord. This is not the stage of when it comes for hearing, my lord, I'll make. But my lord, we will kindly see the main person is what is.
No, that is
convict.
not, what is your health ground?
My lord, my wife is, I have 2 minor child, my lord, and my wife
Two
is
minor child or children?
children, sorry. The plural is children, the singular is child.
Okay.
Two, well, it happens at time. 2 minor children's, my lord, children.
Children's.
Children.
Children. no,
Are,
children.
I know.
You're giving stress to the plural.
Yes.
Okay, understood.
One mistake leads to many, man. Yes, so 2 children.
But you are more interested in getting the bail.
Absolutely, ma'am. That's why. So 2 children and her wife, his wife is suffering from heart ailments. My lord, I have annexed a medical certificate on that ground, and moreover, my lord, at least there is also an element of parity, my lord, because the main man, even the public prosecutor will also, will be fair enough, my lord, that the person who is on bail, he, according to the allegations, my lord, he has stabbed it.
What is the heart ailment?
My lord, kindly come to page number 49 of this IA, my lord.
49.
49. At least even in interim period till Deepavali, my lord, because Durga Puja is also coming till Deepavali, at least, my lord.
What
so
is
that-
the ailment of the heart?
My lord, the ailment of the heart, my lord, it says, Sima Dotto, page number 49.
Yes.
My lord, these are
Chest pain.
chest, chest.
On the left side, chest pain and the
Chest.
medicine prescribed.
Medicine prescribes are prescription are there.
Those people.
Ah, These are all hard, my lord. In fact, my lord, prescriptions are more authentic than certificate.
Sampras.
Oh,
so price
is so well, that's my love.
So, my lord,
Early in the- early in the-
every painkiller is accompanied by a.
Early in the morning, Sampras.
Yes.
My lord,
Omeprazole.
for my lord, nowadays every ailment is accompanied by.
We need to file an objection.
My only thing
The
is that,
mandatory requirement under 389.
my lord, for Durga Puja and Kali Puja, let him be, my lord. Then again he will surrender because the main assailant is to be.
Let him celebrate in the jail, man.
So, my lord, I hope they would have been, I mean, they would have come up with all these objections when the main assailant.
Oh, not on merit, it was granted. It was granted on
Okay,
the
you file
appointment
your,
of
you
the
file your
SACO.
objection, okay. Third, Sri M. Biswas, learned counsel for the applicant. Para, Ms. B. Bhuya, learned senior counsel, acting as the APP, however, prays for and is granted 2 weeks' time to file objection. List thereafter.
My lord, before Puja, one date. We'll try, my lord, before Puja vacation, my lord. Kindly, my lord.
In
Even in the,
Puja, the heart ailment will be gone.
no, my lord, that is what, my lord. At least during Puja, my lord, he can at least take him to for treatment and other things, my lord. Two minor children are also
Puja,
there.
everything will be closed. You go after Puja.
My lord, after Puja, my
Doctors
lord,
will not be there. They'll
my
be
lord, on
celebrating.
last day, my lord, I'll take a chance, my lord. My lord, on medical ground, I have filed it.
After the vacation, we'll have,
Okay.
let her file. You get some better documents of medical. These are medicines everybody takes. Will not make too much of an influence on us.
Lordship.
I am for the informant, my lord, copy it.
Okay. Sri A.K. Bhuya, learned counsel has appeared for the informant. Full stop. Let copy of the IA be served upon him.
As well as
Full
on me, my lord, he'll.
Not
sign
given,
enough to serve a
copy.
My lord, I do, my lord.
Copy served on our office.
Okay.
Yes.
Served upon
I'll
him.
give a part.
The informant may also file objection if so advised.
I'm deep, my
Yes,
lord.
But we have
Yes.
filed this application, my lord. For. No. So only ground of medical, my lord, earlier he
Mr.
was.
Tamuli for whom? Informant. Amicus. Okay. Why amicus is necessary?
Spoke to, he was
Pokso
convicted
matter.
under
Oh,
Pokso.
Pokso, okay. Informant has not appeared. Okay. Yeah, you're filing, bring for suspension.
Lordship, on
Which
release of
IA
bail
was
on
this
medical ground,
second?
on medical ground, my lord, earlier, my lord, page 43, Lordship, can you see? Earlier he was allowed to go on bail, my lord, for 13 period. To
Now, what
go,
are the medical grounds?
to go under surgery, my
What,
lord.
what surgery?
My lord, page 43, Lordship, it was earlier recorded.
4-3.
4-3, my lord. In the order, my lord, dated 14/12/2020. Report was called for from the jail, my lord, jail doctor. Doctor submitted report before the honorable court, and it was in the record also. Page 40. No, that's report. Appeal. Triple page. Report to. I. Thereafter, he surrendered, my lord,
Hmm.
and now, my lord, his condition is more serious, my lord. So, my lord, refresh report may kindly be called for. Now, he is suffering from bleeding from private parts of my lord.
You file objection.
No,
You like to file objection, get a report.
It's on medical
My lord,
ground.
medical
Get a
grounds,
report.
so report.
Get a report,
Get a
okay,
report,
lottery.
get a report. Heard 3 R Ali, learned counsel for the applicant who has filed this application under section 430 of the Bharatiya Nagarik Suraksha Sanhita 2023 for suspension of sentence. Full stop. It is submitted that on an earlier occasion, the applicant was granted, the applicant's prayer for suspension of sentence and grant of bail was allowed as he had to undergo a surgery. Full stop. It is submitted that even now, the health condition of the applicant is deteriorating. Full stop. Para. Also heard, Miss, yes.
Lordship will first peruse the medical documents.
We are
and
not
if you-
granting bail now.
Yes, no, then we need to file an objection if your
If
lordship
you find
considers
out,
the application.
also heard Miss B. Bhuyan, learned senior counsel and APP Assam, Sri S. N. Tamuli, learned counsel has appeared as amicus curiae for the informant. Para. On the prayer of Ms. Bhuyan, the matter is adjourned by 2 weeks to enable her to obtain a report on the medical condition of the applicant, as well as to file objection if so advised.
Lordship, may
Yeah,
give a
List-
date.
we'll fix a date.
before Usama.
Before it can't be two.
No,
it
the
can't be
report,
possible.
only report, other document is not prepared
1 week is it possible,
From-
madam?
from Borpeta.
Try to take.
We'll try
Plus.
on list for consideration on 1st of October. First,
Oh. Okay. A copy before.
I will find it. Okay.
So bail was granted to undergo operation for 3 months. And during that period, he hasn't gone for operation.
operation hold, it you have over here.
One particular problem is a facility or
Sign on, keep us, sign.
Item 17.
May please, Lord. This is for the first time, my lord. Will come up for admission.
We'll admit this.
My lord. No, but one thing I beg my lord's pardon, my lord. What has happened, my lord? Some typographical error in the first title, my lord. It could have been BNS, my lord. It's CRP, my lord.
Doesn't matter.
Well, I may be allowed to correct by hand.
Doesn't matter, we'll treat it. Substantially, it's an appeal.
Yes, yes,
We'll
ma'am.
admit it. N. Mahajan,
Yeah,
Heard. 3 N. Mahajan, learned counsel for the appellant who has preferred this appeal under
It is
section
4152 BNS.
4152 put in bracket
BNSS.
2 of the
BNS.
BNSS against the judgment and order dated so and so. At the outset, the learned counsel has submitted that due to inadvertence, the earlier provisions of the CRPC has been written in the cost title, full stop para. Be that as it may, let the appeal be admitted. Para, let the records be called for. Miss S. Jahan, learned APP, Assam, accepts notice on behalf of respondent number 1. Steps for service of notice upon the respondent number 2 be taken by taken by usual process to be routed through the registry of this court. Full stop. List.
It's not possible. It's not possible. It's 302.
Usual
Oh,
process.
Usual
Let him
process.
raise it.
Registered post we are not saying. Usual process. Usual process. List after 6 weeks along with service report.
And the else.
LCR.
And so we will send, call for the record.
Done.
There's the IM alert. It may be considered after receipt of
By the way, we are not passing any orders. Let it, you press it after in the next date.
May I correct the hospital by hand?
Difficult, not be, we have made the observation, don't worry.
Not required.
My lord. Obliged, my lord. Highly
You
obliged.
can file an amended cost title.
My lord, my lord.
On request, the learned counsel for the appellant is permitted to file an amended cost title to incorporate the provisions of the BNSS.
In my obligement, earlier. CIS officer Thattere correction.
No, it's there in India. Item 18 or আগতে কিন্তু কালি এটা মাথা
কালি পাঠার এটা আসলে না?
কালি পাঠাটা আছে
Terms of Honorable Court's order is 79, 2024. Report has just been received today, my lord, by the registry.
Report of,
Report from
FSL
for an
report.
FSL report, which was received by the.
You want to go
district
through
assistant
it?
judge. Yes.
you want to go through
yes.
the.
Copy में भी था,
Yes, both the
Okay.
sides.
And we can have it next week?
like,
After the vacation.
next week, if possible.
Because lordship,
Appeal of which year? 18?
18.
We'll
my
try
lord.
next week, okay.
Please,
Okay, we'll try next week. This court has been informed that pursuant to the orders of this court, comma, our report has been furnished by this learned district and learned session judge, Nongao, via communication dated 24/9/2024. Full stop. Let copy of the report be furnished to the learned counsel for the parties, namely Miss ADV for the appellant and Miss B. Huya, learned senior counsel and APP Assam. Full stop. The list for consideration on
For hearing,
hearing,
praying for.
list for hearing immediately after the on 22nd of October. We're giving a date.
of that.
Or it to for Mr. Nath, for which matter?
I'm learning it.
Learning.
Yeah,
You are the teacher.
I'm learning it.
কালির matter তুমি আমি বলে গেছি
দুটা কম্পিটিভ
আৰু বেলেগ matter নাই সেইটো in camera to আছে in camera to সোনকালে যদি কৰিব পাৰো
ইনফরমেশন
madam you are there in the in camera proceeding who কি বলছো we can if this matter has to be postponed, then we can have the in camera. If the parties are there, we can give them some time.
ম্যাট্রিমোনিয়াল
Matrimonial.
Perhaps that's not.
কোনোবাটো থাকিব লাগিছিল মই accommodate কৰিম বুলি কৈছিলো কোনোবা থাকিব লাগিছিল
নাই
টাইমটো সোধা নাই না ৰাতিপুৱা কালিতো আমি ক্লিয়াৰ কে কৈছো যে সময়ত নাথাকিলে আমি বাৰু লম
সেইটোৱে কৈছো তেখেতে কৈছে এটা এডজাষ্ট কৰি দিব কাৰণে আমি কৈছো এডজাষ্ট কৰি দিম টাইমটো মেনশ্যন কৰিম বুলি কৈছিলো
এইটো হিৰিং এটা আছে নেকি যে পাৰ্সোনাল যিটো পাৰ্সোনাল পেনশন মেটাৰ উকিল এডভোকেট আছে নেকি
ম্যাট্রিমোনিয়াল ম্যাটাৰটো আছে নেকি
এডভোকেট বিলাক আছে নেকি SK ঘোষ আৰু KL
গুপ্তা আছে KL Gupta.
You are in which matter?
I didn't,
20, you do one thing, you are for the respondent,
yes, no, appellate.
appellant. You inform your clients that we had fixed at 12:40, but since we don't have work, we'll have it as early as possible. Just ask them to report to the court master, both the parties.
Okay.
আৰু সেইটো matter দুটা বজাত বহো নেকি
সেইটো হেৰিয়ে নহয় যে দুটা
দুটা বজাত চেষ্টা কৰিম
দুটাত কৰি দিম আৰু তেতিয়া
নহ'লে আৰু
ৰাতিপুৱা আপোনাক খবৰ পৰা নাই নেকি এইটো কি সময় টাইম ল'ব
আজি নকৰে We'll try at 2 o'clock. Okay. Who was there? Your colleague, Busha?
Yes.
Okay. Where is this set? We'll sit at 2 o'clock.
Yes. What assessing? Sort of say to it.
Single one seated.
If that is it,
Oh.
then we-
We cannot accommodate him like this. We waited for him in the first half. Without any request, we are sitting at 2 o'clock. Nobody was there to make a request even. It's not like this. Had we had some other matters, we would have waited. We cannot wait for a matter. It will be listed after the vacation. A prayer for adjournment has been made. Full stop. List after the vacation. This bench will not be there. List immediately after the vacation.